Okay, good afternoon everyone. Everyone in real life here in the boardroom at Madgwicks and online in the hybrid world we live in. I'm Tim Greenall, I'm a special counsel at Madgwicks, and I'm here today to take you through the Fair Work Reforms 2024, the second wave. It was about this time last year I did a presentation on the first wave, which I guess is more or less it's all in force, but we start all over again for round two. And the reason that we're doing that is because the Fair Work Legislation Amendment Closing Loopholes No. 2 Act 2024 came into force. That is, received royal assent on the 26th of February 2024. As you would have gathered from the newspapers and other media, it had a fairly arduous path through the upper house. A lot of argy-bargy. It's now in force with various commencement dates for different provisions. The second wave of the Albanese government IR changes has actually partly commenced in December. None of us like the goalposts to be moved or things to be retrospective, but the reason why the first lot of provisions that I'm going to talk about today are already in force is because the Closing Loopholes Bill, as a result of argy-bargy in the Senate, got split over two bills, which amount to 600 pages. Unfortunately, not all are finalised in January, so everyone's been absorbing at a pretty rapid rate. So there's about 600 pages worth of legislation split over two bills. I'm here obviously to make it as practical and as as practical and straightforward as is possible. It is the second tranche, so it's further to the changes in the first tranche, the Fair Work Legislation Amendment Secured Jobs Better Pay Act 2002, which is what I was talking about just over 12 months ago. So it's the second wave. To put a bit of context around that, the second wave I would describe it's more mainstream or conventional IR reform. And it's what Labor campaigned for in the lead up to the 2022 election. The first wave, things like pay secrecy, flexible work arrangements being arbitrated in the Fair Work Commission, fixed term contract stuff, a little bit more niche, a little bit more esoteric. This is more hardcore conventional Labor style IR reform. The key changes your business, I think, needs to know about, which I'll take you through. This is an overview. New workplace delegate rights and protections, increased civil penalty orders and criminal liability for wage theft, new employee right to disconnect, the new definition of employment, independent contractor, changes to casual employment, new minimum standards for gig economy workers and contractors in the road transport industry. Now, I hasten to add there are many other changes in that 600 pages affecting specific industries or sectors, but I'm going to focus on these areas of general relevance to every business, the more mainstream things that I think every business needs to know about. But there would be, you could run a series of three of these to get from one end to the other. There's the coal industry, there's the road transport industry, I'm going to touch on gig workers, there's all sorts of areas that come within the ambit of the second wave. But as I said, I'm going to focus on the things I think you really need to know about. So on that basis, the first key issue, this came in rather quietly just before Christmas, new workplace delegate rights and protections. So a workplace delegate, in the old days, we used to talk about a shop steward. So that's actually not on the union payroll, actually on the employer payroll, but is a delegate to the union, appointed or elected by the union, who represents union members in the workplace. And there are new statutory rights that have to be recognised. This is a new concept in our Fair Work Act. They're there to represent the members, including in disputes with the employer. They've got a right to reasonable communication with members and potential members about their industrial interests. must be given by an employer reasonable access to the workplace and its facilities to represent those industrial interests. So you don't have to be a party to an enterprise agreement for this to apply. It's anyone that has. We have a country which we pride ourselves on freedom of association. If there's a union member, those rights must be respected if they're appointed by the union to be. I like to use the term shopping. And down the track a little bit, if delegates for a large business, and the distinction remains relevant, small businesses generally under 15 employees, but for non-small businesses, they're also entitled to have reasonable access to paid time during normal work hours for workplace delegate training. From the 1st of July this year, awards and new enterprise agreements must have a term providing for the exercise of these rights of workplace delegates, and needless to say, a civil penalty will apply to any employer which unreasonably refuses to deal with a workplace delegate, and that's I don't want anything to do with you, or unreasonably hinders the exercise of the rights of the workplace delegate. So just a sort of new niche consideration, which, as I say, is already in force. Right, now, the second area I want to focus on, civil penalties and serious contraventions. Now, this isn't an area I would usually highlight in a IR briefing or update, because I find that people's eyes start to glaze over when you start talking about penalties, because the figures are sort of telephone numbers and it's all rather dull. And the provisions themselves, they're the sort of stuff barristers do actually up in courts and argue about whether it should be 200,000 or 400,000 or whatever. It's not sort of mainstream work. But I am going to highlight it because it has become such headline news these days. And really, in terms of legislative agenda, the union movement have agitated and successfully agitated the Labor government to introduce this stuff to hit employers very, very hard in a number of different directions. So I think I really do need to just give a quick overview of what's going on here. It's got to the point in our commercial work, we're finding that it's very difficult to do any transaction now without getting completely preoccupied and focused on employment law risk, let alone if there are overseas parties involved who can't work out what the hell Australian employment laws are about and what this obsession with penalties are. So in a sense, you've really got to understand what this regime's all about. The big change, and this has been I think 7/11 was the beginning of a whole movement towards penalising underpayment or any other employer misbehaviour or breach of award. But now the maximum civil penalty for companies who are not small businesses, which is only 15 or more, increases fivefold. At the moment, well, in January it was 93,900. It's now fivefold is 469,500 maximum penalty for selected civil remedy provisions, but that includes breaches, pretty mainstream stuff. National employment standards, awards, enterprise agreements, non-compliance of record keeping or pay slip obligations or compliance notices. For serious contraventions, for the sort of systematic abuses that you might read about in the Fair Work Services, that is breaches done knowingly or recklessly, there's that power of 10. So you're now just under 5 million. And from the 1st of January next year, I don't know why this is, well, I guess it is very much aimed at the big end of town. I think universities, supermarket chains and the like, all penalties will be increased to the greater of 3 times the underpayment amount, or that maximum for one breach, serious breach, 4,695,000. I guess what that's all about is it plays into a very recent decision which you might have heard about, which did make front page news. The Fair Work Ombudsman took on the Commonwealth Bank and the Federal Court fined the CBA Group a record $10.3 million over about $16 million in admitted underpayment. So the Commonwealth Bank did come clean with this. So here we're talking about the penalty. It was to more than 7,400 employees going back over 5 years. CBA self-reported and remediated all payments, including interest and superannuation. So they've done all the things that a sensible employer should do, but they are still being stung for $10.3 million because the court was of the view that strong deterrence is required to the CBAs and all other large-scale employers who fail to implement required systems of regular reconciliations and top-up payments necessary for ensuring employees are receiving basic lawful minimum entitlements. This is under enterprise agreements, particularly through annualised salary arrangements, which I think the major supermarkets, Woolworths, have had a lot of trouble with that too, where you roll it all up, here's your composite rate, but you've got to keep checking because in this case, in the CBA, which they also were using annualised salaries, it proved to be insufficient to cover all the penalty rates for all the hours worked by the employees. But in a case, as an example of the new provision, they would now look at 4.695 or 3 times the greater of the underpayment. So there was an underpayment here of 16 mil, so that the underpayment of 1634 plus another 16, they'd work out, which actually CBA would do worse under that new provision. That's what that's about. But on the actual case itself, it's the largest penalty that's been awarded by an Australian court. Of course, CBA are good for the money, but the recommendations to come out of it for all businesses, particularly larger businesses, you need to invest in up-to-date payroll systems and understand and comply with all terms of awards and enterprise agreements. And more importantly, focus on audit and other checking systems. That's what had happened here with CBA. It was set and forget. They hadn't topped up, they hadn't checked to ensure compliance on an ongoing basis, especially, and there was notice of potential non-compliance, which their HR department didn't sufficiently focus on, and it just drifted and drifted until all hell broke loose in 2018. And just as my last point on this rather sobering subject, if that's not enough, there's also now going to be criminal liability for wage theft. The only good thing about that is a very overused term, wage theft. Now we have a statutory concept of what wage theft is, which, as it would traditionally be understood to mean, intentional underpayment of employee entitlements under the NS or award. It's a criminal offence carrying a maximum penalty of 10 years imprisonment if you're an individual employer. There aren't many of those left. Of course, there is accessory liability for those behind corporates. Or, again, this $7,825,000 or 3 times the amount of the underpayment. But the other interesting things to have come out of these criminal theft provisions, wage theft provisions, is that it actually states, as it should when you're talking wage theft, it doesn't include honest mistakes or miscalculations, and employers are encouraged to self-disclose. At the moment, if you've got an underpayment problem, you're out there on your own a bit as to whether you our advice is fix it up, do it. If you can't possibly fix it up, I suppose go to the Fair Work Ombudsman. This is now encouraging employers to self-disclose to the Fair Work Ombudsman so as to avoid criminal prosecution through cooperation agreements with the Fair Work Ombudsman. And something else that's going to come on the radar, I can't provide you with a copy of it yet because I don't think it's actually been issued, but there's going to be a new voluntary small business wage compliance code. So if you're a small business and you think, ouch, that's not right, I've got a problem here, it'll be a bit, at the moment there's an unfair dismissal code for small businesses that you can comply with. It'll be the same it'll be fairly general, but if you've got a genuine issue and it'll create an avenue for you to do a disclosure on the basis that you're now trying to fix it up. But that'll be well worth watch this space for when that actually comes out. So enough of penalties, multiplying and getting powered and multiplied and then to the power of 10. Something completely different, courtesy of the Greens. A little bit of European law comes into our system. The new employee right to disconnect. This was an afterthought, but it's actually been the thing that people have talked about the most and probably is what people are the most interested in. It commences on the 26th of August this year. Unless you're a small business, you get another year to get used to it. It's not actually, as you'll see from that slide, a right to just disconnect, as it's been misconstrued. It's It's an employee does have the right to refuse to monitor, read or respond outside of usual working hours, but only if unless it's unreasonable. You've got a new employee right to reasonably disconnect, might have been a better way to express it, because that is the reality of it. The cases will be about the reasonableness rather than the disconnection itself. It's two-pronged. Obviously, it's a message for overbearing bosses ringing people up on the weekend, but equally it's customers and suppliers. If you're in a service business, you've got to consider for your employees whether they might be customers or suppliers or clients that might be overbearing and intruding on personal time. So that's the second leg of it. And again, it's only if it's unreasonable. So if you're running a 24/7 business and customers ring you within that, well, provided the employees are properly compensated, well, it's probably not unreasonable connection. And with the introduction of European law concepts, I should need to point out, particularly for the people in webinar, it is unlawful in France to eat lunch at your desk. So I know the people here have been well fed. I think that's something to be aware if you're on webinar at the moment. We're going European. What I then have to obviously take you through is, so it's all about reasonableness. So when will it be, whether it's reasonable or not, to disconnect and say, look, I'm not taking that call, I'm out of here. There are 5 factors, which I think, that will be the subject of case law and the considerations as to whether, because it's a two-way argument, this. It's an employee saying, well, I've got the right to disconnect, but equally the employer can be pushing back and saying, no, you haven't. The sort of business we're in, that's not reasonable. So it's a two-way argument, this disconnect. It's not a unilateral right to disconnect. You've got to look at the reason for the contact or attempted contact, how the contact or attempted contact is made, and the level of disruption the contact or attempted contact causes the employee. I think if you're boogieing away at midnight on a Saturday night, maybe getting lucky, 12 o'clock on Saturday is not going to be very appropriate. But maybe 5 minutes past 5 on a Monday night, probably quite reasonable. So the extent to which the employee is compensated to remain available to perform work during the period in which contact was made, think getting paid for being paid to be on call. If you're being paid for it, well, you may well get that call at midnight on a Saturday night. The nature of the employee's role and the level of the employee's responsibility. Well, look, see, here at Madgewix, we're always available 24/7, 7 days a week, but we're paid appropriately, so there's no issue. But as another take you take from that, executive roles are paid to be available. You get the good money, you're available 24/7. So again, and that will factor in. It won't be unreasonable to be hassled on a Saturday or a Sunday, subject to the employee's personal circumstances, including family or caring responsibilities. As I mentioned, this was introduced by the Green Senator Barbara Pocock, who is actually a work-life balance specialist. It's her academic background. She doesn't expect to see a deluge of legal cases about the right to disconnect, but rather the purpose of the reform is to improve the conversation about the boundary between working and personal time. And of course, not to forget, employers already have a general OH&S obligation to provide a workplace that is healthy and safe, including psychologically, insofar as it's reasonably practical. So harassing employees on the weekend may actually not be within OH&S law anyway. So that will factor in. Disputes about the right to disconnect. I'll let you know when I get my first one, it'll be exciting. So the thing to note is that it's offered to the Fair Work Commission, of course. It should be resolved at the workplace, failing which either party. So the employer can take the employee along for not taking the call, just as much as the employee can go along for making the call. So, and it's conciliation, arbitration. It's sort of a little bit like a bullying jurisdiction. You get a stop order, basically. It's not compensation, you get a stop order. Stop hassling me on Saturday night, that type of order. The right to disconnect, of course, is a workplace right, meaning that if you sack someone because they wouldn't take the 12 midnight Saturday call, then that would be adverse action such as termination. So then you're off to the Fair Work Commission. The Fair Work Commission is helpfully going to make written guidelines in relation to the operation of the right to disconnect and whether the employee's refusal is unreasonable or not. I might just say to that I'll take questions at the end. Okay, so the first thing, as I said, we're getting into very much the sort of the old school IR here, the new definition of employee independent contractor, or that distinction, that age-old hoary chestnut distinction between when is an employee an employee with all employee entitlements and rights that go with it, that when is someone at B2B, you're dealing with a business. It comes into force on the 26th of August or an earlier date. I don't think there will be an earlier date, but that's the official advice, so I have to put that up there. Now the test is going to be, we're going to go back to where we used to be prior, or back in 2021. How long is a piece of string? In terms of, it's as a legal practitioner, it's hopeless because you can't actually be very sure, because it's now going to be determined by ascertaining, quote, the real substance, practical reality and true nature of the relationship, by having regard to the totality of the relationship, not only the terms of the contract governing the relationship, but other factors relating to the totality of the relationship, including how the contract is actually performed in practice. Hence I sort of say, well, how long is a piece of string? Unfortunately, in terms of certainty anyway, it's a statutory reversal or overruling of the new High Court approach in those two cases which came out just at the beginning of 2022, 2 years ago, which gave primacy to the terms of the contract. So you could actually have a look at the contract. If there wasn't a written contract, you could infer terms and construct it. An oral contract obviously got terms too. It just has to be inferred as to what they are. But that created a little bit of certainty and objectivity around the test. We're now back to the multifactorial approach. Did you bring your own equipment? Were you treated like an employee? How much control did you have? Could you delegate? All those sort of things with all its uncertainty and potential retrospective operation, because if you get it wrong, it gets backdated. For independent contractors deemed to be employees. It is only Fair Work Act entitlements. It doesn't affect payroll tax, superannuation guarantee, income tax. They've got their own tests and their own definitions. I am talking Fair Work Act, but that's annual leave, sick leave, minimum wage rates, unfair dismissal rights, as an example. There is a new nuancing in all of this. There's an opt-out notice. It's a very commercial concept for a Fair Work Act, isn't it? Very commercial concept. So what a principal might now want to do, you can offer an independent contractor whose earnings exceed what's a new concept, the contractor high income threshold. The employee high income threshold at the moment is $167,500. There's no way the contractor one will be less than that. It might be more. We're not advised yet. It hasn't been. It's to be set by regulation, but it won't be less than that amount. What you can do, you can set a notice of election for because some contractors, some businesses, the last thing they want to be do is to be deemed to be employees. They want to be paid gross, if nothing else. Is a notice of election to opt out of the new statutory deeming definition. And they can opt out within 21 days, because this doesn't come in until the 26th of August after giving of the notice, or at any time after the commencement of the section. So for this new provision, my recommendations are to issue the opt-out notice to preserve an independent contractor relationship where earnings, you're going to do it if they're in excess of the high income threshold, but only if likely the business will be deemed to be an employer, because if they're not, you're opting them in by serving the notice. You're acknowledging that they fall within the deeming test. So you might have to get legal advice about whether they're likely to be in or out before you serve the notice, because as I say, you're acknowledging they're in if you serve the notice. And as a more general point, of course, for contractors that aren't getting revenue, it'll be revenue rather than wages of that amount, you've got to proceed very cautiously now, because there's no opt-out notice if they're under that amount. and you've really been told that we don't like what the High Court did, we want to go back to the multifactorial test. And look, it got to the point, my comment about how long is a piece of string, I mean, it had just moved so far towards it probably will be deemed to be an employment relationship. It was barely worth the risk. You had to do it with a company. That was the only way to fix it. You had to do it with a company or a trust. Yeah. But as for our sole traders, very risky. As part of that rollout for the new independent contractor definition, sham contracting is a civil penalty offence. It continues to be, and there is now a narrower defence based on reasonableness. The sham contracting is actually based on the representation. You represent to someone that it's an independent contractor relationship when at law it's an employer relationship. It's the misrepresentation that attracts the civil penalty offence. There's always been a defence. It's now a more narrow defence just based on you'd have to demonstrate that you acted on good legal advice or on a reasonable basis in continuing to treat the person as an independent contractor. And independent contractors earning less than the contractor high income threshold can now apply to the Fair Work Commission if subject to unfair contract terms. That's a very general jurisdiction, which would mean all sorts of things to all sorts of commercial lawyers as well as employment lawyers, but unfair contract terms, that's a new jurisdiction for the Fair Work Commission. The Fair Work Commission, there are a lot of new commissioners appointed. They're going to have a lot more work to do. We're having a much more regulated industrial landscape. Another one, core thing you need to be aware of, there's a new definition of casual employment, also the 26th of August. So we went through all this casual stuff back in 2021, that long ago, because we had all that carry on about people that had been incorrectly classified as casuals, but they were permanents, so they had very significant back claims, and it affected company accounts. ASIC got involved, whether there was sufficient provisioning, and the idea in 2021 was to clean all of that up. Well, Tony Burke, who if nothing else, he's certainly a protagonist in all of this and an agitator, he's had his own go at fixing it up. We all thought it was fixed up. No, Tony had to have another go, and I'll take you through that. An employee is a casual, this is the new definition. The employment relationship is characterised, that's wording from the cases of that period, but not all of the wording. What's missing there is you'll see there's nothing about the regular pattern of work, just the absence of a firm advance commitment to continuing indefinite work, which is permanent employment essentially, but there's nothing about regular pattern, an absence of a regular pattern, which is where we landed in 2021. And of course, the employer would be entitled to a casual loading or a specific rate of pay. I think everyone learned pre-2021, if you've got a casual, you must identify that separate loading. It was the composite rates that caused all the trouble because people said, oh, well, I just thought that was the rate. I know I want my casual loading. So, and it also meant that it wasn't clear that it was casual employment because there was no distinction in the rate of pay. So that's at the general level, that's the new definition. So what does that actually mean? Whether the employment relationship is characterised by an absence of a firm advance commitment to continuing indefinite work is to be assessed on the basis of, now I have taken this pure slab, cut and paste from the bill, from the legislation, our Act. It goes on for 4 slides. I'm not exaggerating, I have just taken this as a slab. So, it's to be assessed on the basis of, and this is an important question because all sorts of payment implications flow from whether someone's a casual or a permanent, the basis of the real substance, practical reality and true nature of the relationship, well, there's plenty of that in this bill, so we get that, and that a firm advance commitment can be in the form of a contract or in addition to the terms of that contract in the form of a mutual understanding, this is straight out of the bill, in fact the Act, or expectation between the employer and employee not rising to the level of the term of a contract, but may be inferred from the conduct of the employer and employee after entering into the contract of employment, or from how the contract is performed. And having regard to, don't pause for breath, but not limited to the following considerations, which may indicate the presence rather than the absence of such a commitment, whether there was an inability of the employer to elect to offer or not offer work. or an inability of the employee to elect or to accept or reject work, whether this occurs in practice. Still going, having regard to the nature of the employer's enterprise, it is reasonably likely that there will be future availability of continuing work in that enterprise of that kind usually performed by the employee. The key, there are permanent employees performing the same kind of work in the enterprise that is usually performed by the employee. Whether there is a regular pattern of work for the employee, but this does not of itself indicate a firm advance commitment to continuing and indefinite work. That is, an employee that has a regular pattern of work may still be a casual employee if there is no firm advance commitment to continuing in indefinite work. That's actually picking up teachers on contracts that do temporary contracts or the like. And finally, and I know your eyes probably have glazed over at the moment, but I did say it was going to be 4 slides. For the avoidance of doubt, all of the above considerations must be considered, but no single consideration is determinative, and not all considerations necessarily need to be satisfied for an employee to be considered, other than a casual employee. And a pattern of work is regular, even if it's not absolutely uniform, and includes some fluctuation or variation over time. Now, I'm getting a bit excited, aren't I? So I'll put you out of your misery. So that's why it's 600 pages anyway. That is just the new definition of casual employment, which we thought we all understood in 2021. So anyway, so the points to note, they do abolish the definition introduced in 2021, where the employer, the key point is the employer got to determine whether there was an absence of a firm advance commitment to an agreed pattern of work. It's now based on the practice and how it's conducted in practice. You don't get a contractual right. Just like with the contract thing, same with the casuals. Under the old laws, employers got to set the terms, whether you like it or not, at least it was clear. Now it's all about how things are essentially run in practice. There's a significant risk for an employer who has some permanents doing, say, like fruit picking, has some permanents, but also has a couple of casuals doing the same work. Query why they casuals when other people are doing the same work. Now, in terms of surges of labour force and flexibility, that's no doubt a very good business practice, but that's going to run foul of this sort of thing. Although, of course, that's only one of the many factors which may be determinative of the whole thing. As I said, it reverses the recent High Court decisions, emphasising the primacy of the contract and going back to how it's conducted in practice. The preamble to the new sections dealing with casual employment, it's to establish a framework dealing with changes that are quick, flexible and formal, addresses the needs of employers and employees, and again, I'm straight out of the Act, provides for the resolution of disputes to support the employee's choice about employment status. Your guess is as good as mine whether these provisions are likely to work in practice as they are intended, but I think it's very risky to employ regular casuals, which of course a lot of Australian businesses have done for a long time and love doing. And that's what they're trying to stamp out. What's driving this? To restrict the use of casual employment, get people into what's regarded as more secure, ongoing, regular employment, and they may well become union members as well. We also, having got a new definition, we've got new casual conversion rights, but there's actually a little bit of relief for employers in this one. Actually, there's less onus on employers. Ironically, it was good. Tony Burke wanted the both regimes to work, but the crossbench insisted that we don't have two because that's just confusing. So it's actually just the one regime. It abolishes a lot of that Morrison government stuff. So the new casual conversion right, the onus is now on the employee to initiate it. Up till now, employers, and I've got quite a few of them in the room here, you had to, via the Fair Work Casual Information Statement, once an employee casual had been with you 12 months, you had to make an assessment. Or the employee could come to you, but if you're not a small business, you had to make an assessment and let the employee know whether they did have the right to convert to casual employment. Now it's actually initiated by the employee if they want it. It's only 6 months now, it's 12 months for a small business, and the employee believes that the employment relationship is no longer that of a casual employee having regard to the criteria set out above. So that's good luck there. That's the 4 slides I talked about. The employer still has a right of refusal for what are now fair and reasonable operational grounds, including substantial changes would be required to the way that work in the employer's enterprise is organised. There would be significant impacts on the operation of the employer's enterprise. Substantial changes to the employer's terms and conditions would be reasonably necessary to ensure that the employer does not contravene a term of an award that would apply to an employee as a permanent employee. The other two things to know, the employer's got the 21 days and you've got to consult before rejecting it. The employee can obviously appeal by referring it to the Fair Work Commission for arbitration, which is not how the Fair Work Act used to work. It used to be not appellable. So the other things employers need to be aware of in the casual space is that employers will be required to provide, it'll be a new Fair Work Casual Information Statement to casual employees upon the commencement of employment and also after 6 months, except for small businesses, and then 12 months again. And then if you're not a small business, every 12 months after that, just keep on issuing these. It's processed, but you'll have to be and it's a breach of the National Employment Standards not to issue these statements. It's a government thing available on the Fair Work Ombudsman website. It's prescribed, but you'll have to have good systems and got to remind everyone of their rights. If you're a small business initially, and if you're not a small business, every 12 months. And there's a new sham casual contracting provision. We've had sham independent contracting. We've now got sham casual contracting. So if you hold something out as being casual employment, but having regard to the 5 PowerPoint slides, it would be more truly regarded as casual employment. That's sham contracting, sham casual contracting, and civil penalties. So there'll be a jurisdiction that builds up around that. So the last thing I wanted to talk about, and it's actually only one slide, and it occupies about 150 pages of the legislation, but for your purposes, I think one slide is sufficient. It's more of what I would call general interest. The new minimum standards for gig economy workers and contractors in the road transport industry. It will come in August. The Fair Work Commission has a new power to make minimum standard orders for employee-like, that's a new statutory term, workers performing services via digital platform and contractors separately. It's digital, Uber and Uber Eats, Uber drivers. On the one hand, contractors in the road transport industry on the other have got special rights. The Fair Work Commission can set standards relating to payment terms, deductions, working time and insurance. They can also issue guidelines after industry consultation. The big players in the Uber space or in the digital space are in favour of this because they don't want to be undercut by the smaller players. So they are actually part of a consultation exercise in setting. There are guidelines which aren't legally enforceable but set the parameters of the industry, and then there are actual standards that are issued by the Fair Work Commission, which if you're in breach, it's like being in breach of an award. But there are going to be employee-like. It's not the same as being an employee. The British way of dealing with this was actually to deem by statute all Uber drivers to actually be employees with all employee rights. We've done it differently. We've got 3 types of workers. We've got employees, which I've talked about a lot. We've got contractors, which I've also talked about, and we've now got employee-like employees with hybrid rights, halfway house. So from a legal point of view, more sound. Don't try and pretend Uber drivers are actually like ordinary employees because they want the flexibility. They clock in, they clock off. So for our employee-like workers, the Fair Work Commission will not say anything about overtime or penalty rates, rostering or minimum engagement terms, which are in classic award employee provisions, but quite unsuited to digital platforms. Same with road transport workers that like to have their own truck and run their own business, but like a bit of protection too. There's new unfair termination or unfair deactivation. That's actually another one I want to get my first matter in, unfair deactivation dispute resolution processes. Think a little unfair dismissal process for Uber drivers that have been unfairly deactivated for giving lip to Sam Kerr or something like that. So that's what they are the sort of, as I said, there are many, many other things I could have taken you through, but I felt that they were the things you needed to know. There's a huge amount of red tape there as it is. I don't want your eyes to glaze over anymore. I'm open to questions. Yes.
Just with the casual rates, is it asking you to specify the actual casual rate itself and the loading dollar value, or a percentage value is defined? That's it.
Well, you probably would have a look at the instrument that you're going to work under. You'll need to decide which way you're going to go, and I think it talks about whether it's a casual rate set by an award or an enterprise agreement, or under the contract itself, where an employee perhaps isn't covered by either of those two. I would adopt what is provided in the instrument that you're generally employing under. Yep. Now, but I would be very specific to identify that it's a separate loading. And that was the lesson of sort of that period leading up to 2021. Don't use global or composite rates when dealing with casuals. Yes, Jane.
So with all of these upcoming changes, where do you see the key risk areas really lying for employers?
All of the above. I think the key risk areas, contractors, casuals. Contractors, I think, is key risk area. Penalties is just because it's on steroids at the moment, but there's got to be some underlying problem to give rise to the penalty provisions. But I don't think employee right to I think it's entertaining, interesting, but there's no reason that can't be worked through good workplace relations. I think, there's plenty of action in employee independent contractor, getting your opt-out notices right, not overusing it. Casuals, completely fraught, just legislation gone mad. So casuals, contractors. I think they're the key. As I said, this is sort of the old-fashioned hardcore employment law, industrial relations. I suppose if your union delegate rights are completely new, if you weren't expecting it, and you'll be set up if you'll be set up without realising. So if I look at those, right. I've sort of picked the areas that I think where the action's going to be.
Just with the casuals and demonstrating absence of the ongoing commitment, is it emailed to the person to say we just need you for a few months sufficient? You just given a casual contract, or does it something needs to be actually in the contract?
It's something should be in the contract. It should be specified quite clearly what the expectation is, and that's current practice. But where this is different is then it's got to play out in practice. Got to play out, got to be a reflection of the reality. Well, having said that, we're not going to have that terrible situation where people started as genuine casuals and then morphed by default into permanent employment with back payments. Something specific now has to happen. So set it up in the contract correctly, stick to it, and it will hold until the person asks, can I convert? And that's a conversation, that's a healthy conversation, because that's on the basis, I am a casual, but I think things are now to the point where I could convert. And in fairness, I should point out you won't have that sliding default move into permanent employment. That's not going to come back, thank goodness. It'll have to be expressed, but set it out at the outset. But it's got to be, and having said that, it's then got to be realistic. So you can set up a contract saying, we want you as a casual, but if the reality is you've got 3 other people that are doing the same work on a permanent basis and your hours are much for much, then it's not going to pass the test. Yes, Fred.
If certainly as employees, casual or whatever is not overly wrapped about how they've been treated, or a contractor, subcontractor, whatever, they're going to go onto Google, they're going to find these rights, they're going to find the Fair Work Act. What's the process from an employer's point of view to react to that? You know, is there like the cat where there's, you know, you're called into a formal meeting, or
I think a lot of these things are being segued into the Fair Work Commission, aren't they? The employees have got a lot more rights of appeal than they did have to get into the Fair Work Commission. So you will get an opportunity to conciliate and discuss, but you'll have to be well prepared. It's semi-formal, so you'll get a notice of dispute, a notice of hearing. You won't be off to court at first. That would be still the exception. And that would be after Fair Work Commission's failed. Or unhappily, you might get something from the Fair Work Ombudsman saying we want to investigate what's going on. Because that's a statutory power, and they can subpoena documents.
Staff to deal with these things if they get swamped by anybody.
Well, that is, you're right. It's a consumer service. It's a wait your time, but you certainly haven't had a good day if your number comes up as an employer, because they're dealing with a huge range of things, and it's all a bit of, and they only hear one side of the story too. So
you always got the problem of, you know, employees trying to use it as a bargaining tactic. You know,
yep.
Waste your time when you go.
Well, that's it. That you can't stop that. And of course, in the Fair Work Commission and Fair Work Ombudsman, as you know, it's a no-cost jurisdiction. You pay to be vindicated. So this is all preventative stuff. I mean, the people here today are obviously got their risk antenna on, and these are the risks, and you do your proactive compliance and policy framework, get your systems right. You've got till August for most of the provisions, and it's prevention is what it's all about. Because it will cost you to get yourself out of a situation, even if you're vindicated.
Like I've got a client at the moment who's always been a contractor through a family trust. Been doing the same job for 20 years. I said, where's your contracted employment? She said, I signed one 20 years ago, I can't remember. They're now terminated his contract, employed IBM to do his work. And he's saying, I wonder if I was due for long-service leave.
Look, that's a classic example. Yeah, classic. And that's what the cases were like. There were the truck drivers that had done 25 years, they owned their own trucks. And the estate brought the claim, actually. The actual truck drivers were long dead, but the estate had to go and won.
The other one I want to ask about is, you know, I've got a few clients who employ physiotherapists as subcontractors. You know, they work for different physiotherapy practices or doctors because they've got their own health provider numbers. You know, they're considered to be independent. Payroll tax is obviously having a go at them. You know, is this sort of going to be an area where they're going to let the doctors or the employer physios are going to be saying, well, I've got a now problem with the subcontractors who subcontract because they've got this government accreditation and now no longer subcontractors, they're employees.
And that has happened in the Victorian payroll space, hasn't it? I mean, that's actually got in the media too, because the doctors are saying they're going to have to shut up shop. They can't pay payroll tax. As I said, this is a fair work definition, so it won't impact per se. It won't impact payroll tax, superannuation, income tax, withholding obligations, but it sets the tone. It sets the context, and there's going to be. I think the High Court approach was a bit of an unexpected panacea in the space. It sort of came out of nowhere, or came out of the High Court, and it was terrific mitigation for employers. That is, principals basically who didn't want to be employers. That's right. It was basically, we've got a contract. This is what it says. This is what it means. Basically, said you've got a contract. It says what it means what it says. No second guessing.
Definitely, it's your problem.
That's right. Yeah, but now we're back to now we're back to, I think, sadly, we're almost back to how long is a piece of string in particular cases. The way around it, deal with incorporated entities or trusts or not individuals.
got a question from online. So someone's asked, could you touch on the new laws introduced in December 2023 with respect to fixed term contracts and whether any matters have come across your desk in the last few months in relation to them?
Oh, well, see, you should have been here. This person should have, I hope they were here this time last year. But it's a fair point. It came December, actually, you know what? It's December the year before it came in. Yeah, but anyway, same thing. Yeah, fixed term now. Fixed term, what you can't, if you've got someone on a term contract, you can't run it for more than 2 years or you can't renew it more than once, is the basic rule. There's now a Fair Work Information Statement that sets out what's required. You have to, that statement got issued in December actually, so everyone got a good look at how it would work. It's been a civil penalty provision since June last year. So if you actually try and breach it, not only is it meaningless, it doesn't work, you're actually up for a civil penalty as well, which means you could be up for 1 time or 10 times those horrendous figures. It's not a serious contravention, I wouldn't think, but I haven't had to deal with the matter as such. There was quite a long lead-up time. It affects particularly universities who use fixed terms, government contracts, yeah. But I think there was a reasonably long lead-up, so I think most organisations got savvy and prepared for it. And of course, it doesn't get triggered until you have a renewal, but of course, an existing term prior to the commencement of the legislation counts as a contract, or you're pushing it out beyond 2 years. That was the first tranche. But there's a good Fair Work Information Statement, though, that explains all of that. And you have to provide that to any fixed term employee or term employee.
And it's just one other question as well. Why do the provisions apply from 26 August?
Because it received royal assent on the 26th of February and it said it'll come into force 6 months after the date of royal assent or earlier by proclamation. All right, dessert? Yeah. Well, we might do the French thing, I think. Will we do the French thing and we'll close this out and we'll have some more to eat. Unless there are any other questions. Thank you very much for your attendance today. Let's have dessert.